Dollemocracy. Facing down pessimistic politics with realistic optimism.
So, one way to know that I'm really fun and cool is that...
There's only one way, or this is just one of many ways?
It's one of many. Is that I like listening to the Supreme Court oral arguments when they happen. And
this is not a joke.
Play them on my phone like they're a podcast while I'm doing what I need to do.
I will be down in the studio working, and I will hear an echoey chamber with voices in it. And like, what in the hell is going on up there? This has happened multiple times.
Yep.
And I'll go up, and it's you, because there's no video of it. It's an audio feed, listening to live arguments of the Supreme Court of these United States. And in this case, I think we're getting ready to talk about the case related to gun rights, or the restriction of gun rights to people who have been convicted of domestic violence.
Yes. So, like I said, it's one of the ways I'm cool and fun. It's right up there with me being in a bean club and how like taking naps are my favorite hobby. So, I selected 3 segments from this recent case that you just talked about, Jesse. It's the U.S. versus Rahimi, and they're basically deciding whether to uphold a federal law that prohibits people under domestic violence restraining orders from owning firearms. Seems like a good thing to prohibit.
Yes, Brittany Page, but that would be common sense, and this is the United States of America.
Yeah, but so based on how the oral arguments went on Tuesday, experts are saying that it looks like the Supreme Court is going to uphold this federal law, which is great. But that will potentially limit the scope of their gun rights ruling from last year. And the case last year is the New York State Rifle and Pistol Association versus Bruin. And you're going to hear Bruin in some of these clips that we play. And that represented the widest expansion of gun rights in like a decade when the Supreme Court gave that ruling last year. And in that case, they struck down a New York gun law that was enacted a century ago that places restrictions on carrying a concealed handgun outside the home. And this has basically created a situation now where lower courts are analyzing all different kinds of gun restrictions in the country based on the historical understanding of a right to bear arms. So it's basically opened the door for gun rights activists to be like, okay, well, let's start looking at all these different gun restrictions under this new ruling and get all these gun restrictions lifted. So on Tuesday, the Solicitor General, Elizabeth Prelogar, who is absolutely incredible, amazing. Yeah. Every time I listen to oral arguments, I am so amazed by her. She basically made the argument that this prohibition of certain people not being able to bear arms fits within a long tradition of disarming people who are considered dangerous to society. Now, this seems like obvious.
Yeah.
Obvious, but it's sad that they need to find somewhere that it is rooted in tradition and history in order to implement it in 2023. Like, that's where we are.
Yeah.
The Supreme Court needs to find history and tradition.
Imagine being in a position where you're fighting for the rights of someone who has a history of violence against other people, marginalized groups, weaker than them physically, like a partner, and then wanting them to have access to deadly weaponry.
Wow. Enter J. Matthew Wright, Jesse D., because he's the attorney arguing against the Solicitor General, Elizabeth Prelogar. And we'll get into the client that he's representing, Zaki Rahimi, a Texas man who had a no-contact order or a domestic violence restraining order put into place after he was violent. And this first clip is going to be Ketanji Brown Jackson, the newest Supreme Court justice, going back and forth with J. Matthew Wright, this attorney who, again, is arguing against the U.S., going back and forth about what history and tradition means in this context. What is the history and tradition test? And you'll start to quickly understand why experts are starting to see that the Supreme Court is going to rule in the way that they should on this case.
It sounds like they may still be on the table for some other person who's outside the political community. I say you don't look at them at all because, number one, they're awful. They're terrible laws. We should not give credence to a suggestion that a legislator in 1870 in the South. We should not.
But we have a history and traditions test. I guess I'm a little troubled by having a history and traditions test that also requires some sort of culling of the history so that only certain people's history counts. So what do we do with that? Isn't that a flaw with respect to the test?
Your Honor, I think what you do is the Bruin test starts with the text. And so ultimately, historical tradition, as I understand it, is something the court does to make sure its textual interpretation is correct and consistent with the original understanding of the amendment. So in the situation that you're describing, those laws, they were not people who were part of the community. They weren't seen as the people. And when these laws were challenged, including in this very court, that was the reason. Well, this court was not dealing with a disarmament law, but other laws that were targeted those groups.
So does that mean only Reconstruction era as opposed to, only foundational era as opposed to Reconstruction era sources are on the table here?
For purposes of the Second Amendment and applied against the federal government, yes, absolutely. It is only founding era sources and immediately after the founding era. So people who understood they were bound by that. Like, again, I don't see these two steps of Bruin as completely separate pieces. You pass the text point and you move on. The court is trying to get at the meaning of the text, the original public meaning of the text.
And in your view, with respect to domestic violence, are we looking for history and tradition in the Reconstruction era about how regulation was happening in the circumstance of domestic violence, or no? I mean, the government says it can be done at the level of regulation of dangerous people with respect to firearms. But you seem to be suggesting, and I think this is going back to a question that Justice Kagan asked, that what we're looking for is Reconstruction era sources, I suppose, that applied to the regulation of white Protestant men related to domestic violence. Is that sort of the level that we are focused on when we're trying to find a history and tradition?
No, Your Honor. And I may not have been clear before. I think it's the founding era, not the Reconstruction era, when we're talking about the federal.
I apologize. The founding era.
And it has got to be the people, someone who would have been understood to be part of the people, a rights-holding citizen.
Right. The people doing what, though? Do we drill down further and say it's the people, which in that case did not include all the people, but fine, we've identified the relevant people who are being regulated. Is it enough that they were being regulated with respect to just dangerousness, or are we looking for a regulation concerning this set of circumstances?
It doesn't have.
This is always. So when I'm listening to this, I am often feeling frustrated because it's so strange that you're in the year 2023 and you're talking about, can people who are under a restraining order for domestic violence, can they keep their weapons when they are dangerous? They are dangerous to society. They have done something dangerous to the point where they need to be placed under a restraining order in order to not go near the person that they have been violent toward.
Yeah.
And we have to look to the founding era documents to find the root of history and tradition to see what it tells us about this issue. Why in God's name would we do that? And Ketanji Brown Jackson is very good on this, where she always brings up that only certain people were included in this history that they always want to go back to. It wasn't everybody, only certain people. Yeah,
he called them rights-holding persons. Listen, when you go back to the founding of our country, especially the initial version of our Constitution, the Constitution of the United States, and then include the Amendments 1 through 10, only white land-owning men could vote. They were the rights-holding people. So other people didn't have rights. We weren't really a democracy until the full franchise had been realized by women and black people. It's egregious for him to make this argument. My second point is, one, he is a dum-dum. He is not good at this at all.
He's so bad at it.
But it's not just the rights-holding thing. It's the fact that he's not making an argument, and ostensibly he doesn't have a problem with someone's rights being curtailed relative to a no-contact order, a restraining order. That is a curtailment of rights. It's curtailing where you can go, with whom you can associate. That's not a problem. But apparently curtailing them just the next step to not allow them to have a deadly weapon is, oh my God, that's a bridge too far.
Yeah.
Ugh.
Well, and to really drive that point home, Jesse, I want to talk about the person that is his client, Rahimi. The name of the case, U.S. versus Rahimi. Zaki Rahimi is this person's name, and he had his ex-partner obtained a restraining order after an incident in Arlington, Texas, in a parking lot in 2019, where he hit his partner, dragged her to his car, pushed her inside, knocked her head on the dashboard, and fired a shot from his gun in the direction of a witness. Okay, this sounds like a dangerous person.
Unhinged.
Who should not have a weapon.
Yeah.
And there was actually a point, even while the protective order was in place, that he was implicated in a series of shootings, including one in which he allegedly fired bullets into a house using an AR-15. Okay, so this is an unhinged, dangerous person who should absolutely not have a weapon. There was a point in the exchange between the justices where Chief Justice John Roberts actually asked Rahimi's attorney, the guy that you just heard fumbling over his words, Ketanji Brown Jackson, whether or not his client should be considered dangerous. And he said that he would need really a definition of what dangerous is. I mean, these are the people that we're dealing with.
Yeah.
So,
Just shameless lawyer shit, man.
Yeah, and it was not going well for him with anyone. I mean, there was a point where, and we're going to play this now, where Elena Kagan actually called him out and said, listen, you're running away from your own arguments.
There's definitely a tradition for restricting sale or provision of weapons to the mentally ill. That all the examples that the government has cited are late. They're post-Civil War sources, I think, for that. If not, so I think maybe is the answer to this.
I'll tell you the honest truth, Mr. Wright. I feel like you're running away from your argument. Because the implications of your argument are just so untenable that you have to say, no, that's not really my argument. I mean, it just seems to me that your argument applies to a wide variety of disarming actions, bans, what have you, that we take for granted now because it's so obvious that people who have guns pose a great danger to others, and you don't give guns to people who have the kind of history of domestic violence that your client has, or to the mentally ill, or what have you. So I guess I'm asking you to clarify your argument, because you seem to be running away from it because you can't stand what the consequences of it are.
Your Honor, I am running away from interest balancing because I understand that same sort of argument could have been made in Bruin, could have been made in Heller, could have been made in McDonald, and in fact were made in all of those cases, right? Legislatures have made a judgment that it is dangerous to have people carrying weapons about. Legislatures made a judgment it's dangerous for handguns specifically to be possessed. And the court didn't defer to those late or mid-20th century judgments or even early 20th century judgments about dangerousness in that scenario. Instead, the court said, we are going to follow our understanding of the original public meaning of the text and as illuminated by the historical tradition of firearms regulation at the margins. So I guess that's what I want to say is that if there's no such tradition, so if you couldn't, I'm supposing that we would find examples of people having firearms removed from them if they are in imminent danger to others. That historical record has not been built in this case because that's not the kind of law that we have. I do believe that it's there, and I could give some additional examples where I think we could find support for that. But if not, if there were no historical support for that, we would be left with what the text says, which is you have a right to keep arms. And so in that sense, that would end.
You have a right to keep arms. It seriously is the most bizarre thing to me. The Second Amendment is a bizarrely, poorly written phrase for the security of a free state, the thing about the militias, and then the right of the people to keep and bear arms shall not be infringed. There's a bunch of commas in there that don't make any sense and don't need to be there. It is, it is so confusing, one, that this guy is arguing before the Supreme Court of the United States, fumbling and bumbling and arguing his way out of his own argument. But the other thing that I would really love to know more about, I wish I was more educated about the law in this way is these, well, all of their arguments are late. They're like post-Civil War. Who decided that the history of the United States only is the founding period relative to how we interpret the laws? They're just, it doesn't jive. I don't get that.
It's scary. Yeah. I mean, it's scary, especially when we're talking about things like this. And this attorney writes, he, I would get it if he was representing someone who like had been wrongfully accused or something, but he's like representing someone who has actually assaulted more than one woman.
Serial offender.
So I just like, is this the best person to be like, and what does dangerous actually mean? And are we really overstepping and taking this man's gun away? I mean, like, no, we're not overstepping, dude. Like, please. But I know that we played only liberal justices, but Amy Coney Barrett joined the chorus of people who were like, dude, I am so confused. And can you imagine you're arguing before the Supreme Court and a justice says to you, I am so confused.
Especially a conservative one like Amy Coney Barrett.
Yes.
I'll say this. Imagine a statute that had been written that was the what Zaki Rahimi has been accused of statute. And very prescient legislators, way ahead of the game. If you have done all of these 9 things and it's proven to a constitutionally significant level of abstraction, you don't get to keep your gun. We're going to come and take it from you. And you just don't. Constitutional, 100%.
I thought you just said no. I thought you said there's no history of any kind of ban for anything that doesn't relate to felonies.
I want to be clear that there is no one that I've found anyway. I think it would stem from a court's either historical equitable powers or the rights of the government to literally protect someone from imminent danger to life and limb. There are examples, some of the early Justice of the Peace manuals that talk about if you see someone who is on the way to commit a crime with a weapon, you can take the weapon away from them and you don't have to institute proceedings immediately. However, you do have to institute them pretty quick after that.
I'm so confused because I thought your argument was that there was no history or tradition, as Justice Kagan just said, of this kind of disarmament in this circumstance, but now it kind of sounds like your objection is just to the process. Like, are you making Judge Ho's argument only?
No, Your Honor, I'm not making Judge Ho's argument only. The law that's before us right now is a...
Do you love just hearing him panic?
When Amy Coney Barrett turns on you look for a different job, dude. Also, he's referring to early justices of the peace manuals, like how do they do their job? Like, is that from the founding era, justice of the peace? Is that from the early founding? What a muddled argument. What a terrible representative for this particular ideological stance. What a terrible candidate. What a terrible client to bring this case before the Supreme Court. Gun rights experts and gun rights advocates have to be very, very disappointed.
Yeah, I mean, thank God it went this way, and I mean, I think it just speaks to Elena Kagan's point, which is that it's so untenable what he's arguing that there's no real way to argue it effectively. So like he's just kind of set up to lose because what he's trying to say is not tenable.
Well, also, it's not just not tenable relative. I mean, here's the overarching theme here is that the right, their zero tolerance restrictions on gun rights, their Second Amendment absolutism, this is where it will lead. This is what they want. They want dangerous individuals to be able to keep and possess weapons, use them unrestricted. That's the country they want. They want the fucking Wild West or the wild colonial period because that's the only part of America that matters. It's crazy, but it doesn't just portend for how they want the country to run relative to guns. It's also everything else. It's abortion rights. It's rolling back bodily autonomy. It's a dangerous country that they want to form.
Yeah, for sure. So I think it's rare, unless you're, a sad loser like me, that you hear in-depth...
You're a happy loser. You're a happy loser.
Where you hear in-depth reporting on the oral arguments, and you actually get to hear from the justices themselves. And I mean, these were an hour and a half long or something, so it's it's a lot of time and dedication. But I felt like this was a really important case, so we needed to talk about it.